I want to talk to you about IR35, and I've done a little guide for the self-employed. So a quick IR35 definition and why IR35 exists. IR35 is another name for off-payroll working rules. It's designed to assess whether a contractor is a genuine contractor rather than a disguised employee for the purposes of paying tax. Contractors who work through their limited companies enjoy a level of tax efficiency. While they don't usually get employee benefits like holiday and sick pay, they have flexibility and control over their work. So some contractors and their clients try to take advantage of this tax efficiency by working as if they're self-employed, when for all intents and purposes, they're employees. HMRC has designed the off-payroll working rules to tackle this, but the rules aren't without problems. IR35 nuances mean that contractors can't be expected to know the law inside out, so please only use this article as a guide. If you're unsure about anything, then book a call with me. IR35 helps HMRC tackle tax avoidance through off-payroll working. HMRC introduced IR35, or the off-payroll working rules, in 2000 to tackle what it calls disguised employment. When a contractor is a disguised employee, they might be taking advantage of the tax efficiency of working through a limited company when they're really an employee for the company. The benefit for an employer is that they don't have to pay employers' national insurance contributions or give the contractor employee benefits. The benefit for the contractor is that they can pay themselves tax efficiently. So IR35 is essentially an employment status test for tax, which works out whether a contract points towards employment or self-employment. If your contract is inside IR35, it points towards employment. And HMRC sees you as an employee and you face an income tax and national insurance burden just as employees do. If your contract is outside IR35, it points towards self-employment, and you can enjoy the tax efficiency that self-employment brings, as well as all the associated risks. But IR35 rules are complicated and controversial. Many find the legislation complicated to understand. Even HMRC seem to struggle. Its record on fighting IR35 cases at tribunals is patchy. In 2019, TV presenters Kay Adams and Lorraine Kelly successfully challenged HMRC in separate cases, proving they weren't inside the rules. A lack of clarity, along with ambiguity over employment status guidelines, including available employment rights if the contractors are found inside 35, has been controversial. So how do IR35 rules work in practice? When does IR35 apply? HMRC says that when working out whether IR35 applies to a contract or engagement, and this is in inverted commas, you must work out the employment status of the person providing their service. HMRC goes on to say that the off-payroll rules apply if the contractor would be an employee, if there was no intermediary. The intermediary in many cases is the contractor's limited company, which can sometimes be called a personal service company. What is an intermediary? IR35 is also known as intermediary legislation because it applies to workers who provide their services through an intermediary rather than working as an employee. As mentioned, the intermediary will often be the contractor's own limited company or a personal service company. A personal service company is a limited company where the sole director, the contractor, owns most or all of the shares. The contractor then delivers services to clients, a partnership, another personal service company, an individual. A contractor can provide their service directly to clients through their intermediary, or they might work through an agency or what's called an umbrella company. What does IR35 status depend on? It relates to three things: supervision, direction, and control. And I've got a checklist further on. HMRC also has a tool called CEST, Check Employment Status for Tax. You can use it to check your IR35 applies to a contract. But in reality, IR35 status hinges on IR35 case law and employment legislation. It's self-reliant on decades worth of employment tests heard in the UK courts. Another problem is that CEST may not be 100% accurate, as it doesn't take a key piece of case law, mutually of obligation, or MOO, into account. And I'll go on to explain what MOO is later on. So who works out your IR35 status? There are currently different rules for public sector and private sector contracts. Off-payroll working rules in the public sector, the hirer is responsible for working out whether the contractor falls inside or outside of IR35. If they fall inside, the hirer, agency, or other third party who pays the contractor then needs to deduct tax and national insurance and report them to HMRC. Off-payroll working rules in the private sector. The contractor is responsible for working out whether they fall inside or outside of IR35. If they're inside, they need to pay the tax and national insurance due. But this is set to change in April 2021. Private sector IR35 reform is set for April 2021, when the public sector off-payroll working rules will be applied to the private sector. Now, this was meant to happen in April 2020, but it was delayed a year because of coronavirus. So the upcoming IR35 changes mean that medium-sized and large businesses will be responsible for working out the contractor's employment status, not the contractor. And it's just medium-sized and large businesses. Contractors should be given the reasons behind the decision in a status determination statement and can dispute the decision if they disagree with it. Small businesses are exempt from the changes. So if a contractor works for a small client, the contractor will still be responsible for working out their employment status. End clients are classed as small businesses if they meet two of the following criteria for 2 consecutive financial years. Annual turnover of no more than 10.2 million, balance sheet total of no more than 5.1 million, and no more than 50 employees. That's what's classed as a small business. End clients need to show they've taken reasonable care when working out IR35 status. If they haven't, HMRC will hold them responsible for getting things wrong. So businesses and contractors should prepare for the 2021 IR35 changes. So I've done an IR35 checklist which can help you get IR35 compliant. So the checklist. In general, IR35 won't apply if the contract is for services rather than employment. To untangle that, you should see whether the contract specifically mentions these principles. Supervision, direction, control. This relates to how much say your client has over how you complete your work. So for example, if you have to work at certain times, this implies employment. Substitution. Could you bring someone else to complete the contract, or do you need to do the work yourself? If you can't send someone else, you're likely to be within IR35. And the one that I spoke about before, Neutrality of Obligation, MOO. Is there an obligation on the employer's end to offer work? And do you have to accept it? This is called Neutrality of Obligation, and if an element of it exists, the contract may fall inside IR35. The contract has to reflect your actual working practices. Essentially, the clauses need to be genuine. So supervision, direction and control. For a contract to fall outside IR35, contractors should have freedom over how they complete their work. A contract that specifies things like the time you can start and finish or the days you're required to work points towards employment. A contract might also point towards employment if a client oversees your work excessively and gives guidance on how to complete it. Plus, if you're not only providing your service for the agreed job, but also working on different tasks as your client sees fit, the contract is likely to be inside IR35. Substitution. For the contract to fall outside IR35, you should be able to send a substitute to complete the work instead. So does your client only want you or services more broadly? Outside IR35, contract might state that someone else can provide their service to complete the work. The clause has to be genuine. You should know which skilled contractors you would ask. Plus, the contract can't be so restrictive that you essentially need to do the work yourself. Neutrality of Obligation, or MOO. This is an important clause in the contract, and it's a key test when working out self-employment status. If the client is obliged to offer work and pay you, and you're obliged to demonstrate it, this demonstrates a contract of employment. In practice, this means a self-employed contract involves working on a project-by-project basis. Once you've completed a project, you're under no obligation to work on further tasks, and the client is under no obligation to offer them. You should also consider whether you can work for other clients simultaneously. If that's prohibited, it points towards employment. Some other things that you need to think about. Equipment. HMRC often tries to argue that if equipment is provided by the client and you don't use your own, you're a disguised employee. Financial risk. Self-employed contractors usually take a degree of financial risk, like any other business. Are you responsible for errors made during the contract? And would you need to rectify them in your own time? there's usually a requirement to have professional indemnity insurance. The way you're paid. Self-employed people are paid on a project basis, which might mean when the work is completed or at a particular project milestone. Part and parcel of the organisation. If the contractor becomes so ingrained that they become part of the company's structure, with people reporting to them, for example, this points to employment rather than self-employment. Exclusivity. It's easy to say. Do you work for other clients? Typically, self-employed can work for multiple clients at once. Intentions of the party. The contract should make sure the relationship between the contractor and the client is one of supplier and customer, and this should be genuine. If HMRC found the actual intended relationship is more like an employee and employer, it'll ignore the contract. Business on your own account. Essentially, this determines whether you're actually running your business as a business. If you have things like a business website, a dedicated office space, or even employees, you could be seen as operating a business and not offering your service in the same way as an employee. Make sure you clarify your relationship with the hirer before you start the contract by considering all of these principles. Again, before you start working, you should seek expert IR35 advice. And I state, only use this article as a guide. If you're unsure about anything, then book a call with me. My name's Susan Crichton from SJC +0 Accountants. Thank you for listening. Bye.